In this video, we're going to share some of the best things we've learned at the second day at the AILA Chicago conference in 2024. Let's go. Number one, if the petitioner passes away, can the beneficiary still get the green card? Yes, and there's three ways. The first is the 360 widow application. This is the one where it automatically converts. You can look it up, 360 USCIS. The second way is a 204L exception where you have to claim it and argue it. There are much stricter requirements. For example, you need to be physically in the US on lawful status. There's several of these physical presence tests, but you're able to get the green card even if it's still pending. And the third is the humanitarian reinstatement catch-all provision, which still allows people to still get the green card even if you don't qualify for the first two. Number two, if you're a green card holder overseas for a substantial amount of time, how do you get back into the US? Well, there's three main methods. One, you must have a reentry permit. They highly recommend this. Number two, you should try to get an SB1 visa. And number three, you can present your case with the CBP officer and let the CBP officer review your case and let you in. If you have a situation like that, if you left the US for a significant amount of time, don't lose hope. A green card is not abandoned until it is abandoned. Three, EB2, EB3 backlog. Some people have to wait an additional 5-10 years before they can get their green card. From what we heard from the Department of State, backlogs are going to continue and get even worse. So what do you do in this situation? Try to convert it to EB1 because EB2, EB3 priority date can be converted to EB1. And EB2 backlog typically is shorter and is going to get shorter, argued by some. So how do you go from EB2, EB3 to EB1? There are a couple methods. If you have the ability to be an executive or a manager for your company, well, instead of waiting in the US, ask the company to transfer you to their subsidiary branch overseas as long as they're an affiliate relationship. Work there for 1 year and then transfer back to the US. Then you argue the EB1C and you can preserve your EB2, EB3 priority date. Second way is if you are pretty good in your field, you could directly apply for the EB1A. And if that gets approved, you can obviously use your EB2, EB3 priority date and then convert. We have an entire success story on this that we just did. It's linked below. It's shown right here. So just take a look. But that's how somebody who has an EB2, EB3, who does not want to wait, file EB1A within a few weeks, get that approved and file the adjustment of status and get the green card. So that is the second takeaway. Third, big public announcement, National Visa Center are no longer accepting email inquiries. So if you've been emailing them, good luck. No one's going to respond to you. What you need to use is their public inquiry forum. Last but not least, the statewide visa program is a raging success that USCIS director talked about, that Department of State talked about. So the good news is that this pilot program is going to be extended. And the crazy thing is we didn't know this before, but this was a policy that happened 20 years ago and it got canceled. And so now the consulates, they were building up the consulates all around the world and they were able to do it. But now they're bringing it back to process in the US. It's almost like 20 years ago, the US government decided, hey, let's outsource this problem and let's not do it internally in the US because it's too expensive. Let's outsource it to consulates all around the world. And then COVID happened and all the consulates shut down and they had to bring it back to the US to help the consulates abroad. And it turns out this might be a good idea. And so they're ramping up hiring in the US to process the cases. Right now, it's very limited to certain visa categories, but eventually it's going to be rolled out to all the other big visa categories. Now, this is my personal prediction. This is going to cause a pretty major problem between the have and the have-nots, meaning if you already have a visa approved abroad, you can come to the US and get it extended and things will be easier potentially because filing with USCIS is sometimes easier than dealing with a consulate. And their consulate, they're going to shrink in the number of people that they need all around the world. So if you think it's difficult to deal with a consulate now, it might get even more difficult, even though technically their workload is decreasing. But because their workload is decreasing, they're hiring less people. And because the people who already have visas are in the US and they're extending it, now they're going to be stricter to the people who don't have it yet, who are applying for the first time. So if you don't have a visa, it's going to get harder to get one, just like the K visa. We've seen this in the past. I predict we're going to see in the future. Prove me wrong. And that's it for day 2 summary. Check out our day 1 summary where we did at the AILA, and we're going to do a couple more days down ahead. Let's go.